Testing 1 2. Testing 1 2. Testing 1 2. Testing 1 2. Well, all right. All right. Ladies and gentlemen, let's get something straight from the start. The moment you are placed in police custody, your freedom of movement is stripped away, as so is your ability to care for yourself. You can't go to the doctor if you're sick. You can't walk out and get food or water. You can't protect yourself from abuse. And that's the exact moment under American constitutional law you become a ward of the state. This isn't my opinion. It's black letter law. The Supreme Court has said over and over again, when the government takes away your liberty, it takes on a new duty, an affirmative responsibility to safeguard your health and your well-being. Now, things we're going to get into as far as the progression of the ideas that are being placed in front of you are, in the Supreme Court case of Estelle v. Gamble, the court ruled that ignoring the serious medical needs of a prisoner is cruel and unusual punishment, which is an Eighth Amendment violation. In Farmer v. Brenner, they expanded that, saying prison officials can't just ignore risks. They become liable if they know of a danger and do nothing. I'm going to read that one again because this one is one because of our prisoning system. They expanded on Estelle v. Gamble with Farmer v. Brennan, saying prison officials can't just ignore risks. They become liable if they know of a danger and do nothing. And even if you haven't been convicted, if you are just awaiting trial, the protections are even broader. And remember, I spoke about 80% of our current policing and jailing system. Most of 80% of those people have not been convicted of a crime. They're there due to bail, not being able to make bail. They're waiting on trial, which means their protections are even broader because they should not even be subjected to felonious conditions. Now, the 14th Amendment kicks in, and in City of River v. Massachusetts General Hospital, the court said police and jailers must provide medical care to arrestees who are injured. And in Kingsley v. Hendrickson, the court clarified that pretrial detainees are judged by an objectively reasonable standard, not the officer's intent, because they have the right to remain innocent until they are proven guilty. So again, subjecting one to felonious conditions prior to being convicted is a liable action on the jailers. Now, what does that mean in plain English? It means that whether you are awaiting trial or serving a sentence, the government owns the responsibility of your survival. Whether you are awaiting trial or serving a sentence, the government owns the responsibility of your survival. They don't get to shrug and say, well, accidents happen. They took away your ability to protect yourself, and in doing so, they took on a constitutional duty to protect you. This isn't about luxury treatment. This is about the basics: medical care, food, safety from assault, and humane conditions. Once you are in custody, the Constitution puts the burden on the state to deliver those basics. And when they do not, it's not just negligence. It's a violation of your civil rights, actionable under 42 U.S.C. 1983. So let's be clear. If you or someone you love ends up in custody, the law says the government must protect them. If they don't, they can and should be held accountable. Now, why did I come up with this, right? Because people actually have questions about let me stop this. It was a statement made in a video I posted where a young man stated that the government does not have responsibility for your care just because you're an arrest. Now, I'm reading off, again, Supreme Court cases that state otherwise, because I may state something one time without the clarification of the case, but now that I put the case out, understand that this is exactly what it is. I don't just talk just to be talking. This is one of those things that most people don't have a real understanding of. And even when the direct answers, once you are in police custody, you no longer have the same ability of care of your own, your health, your safety, or even basic needs. At that moment that you are arrested and taken by police, you are now legally a ward of the state based on the Constitution, based on Supreme Court decisions, based on whole autonomy. That means even though the police, jailers, or prison officials assumes an affirmative duty to protect you and your well-being, this duty is not optional. Always understand that. And this is why whenever I look at these police attacks on the people when they're arresting them, those are just what I label them as, an attack. Because it also shows you the systematic interest in more or less reverberating the ideas of control until they're responsible within their own control. Now, this duty is not optional, it's constitutional, and it's mandated under the Due Process Clause of the 14th Amendment for pretrial detainees and under the 8th Amendment for convicted prisoners. The Supreme Court has consistently held that when the state takes away someone's liberty, it also takes on the responsibility of their health and safety. If they fail in that duty by showing deliberate indifference to serious medical needs, subjecting detainees to unsafe conditions, or ignoring risks, they can be held liable. Now, I don't know what's going on with my eyes. My eyes have been hurting lately. Anyway, I'll give you kind of a step-by-step legal basis. Custody equals lost autonomy. So I'm gonna leave that out there because I know a few of you are gonna wonder what's going on and what I mean by that. But when a person is arrested and held, they cannot seek medical care, food, or safety on their own. This creates what the courts call a special relationship between detainee and the state. Get a little sip of this water. Now, the 8th Amendment is something that we're going to get into. But remember, when we're talking about this, the relationship, because again, I talked about a fiduciary duty, we must prove there's a prior relationship for that duty to be enforceable. Here, it talks about the arrest creates the special relationship to now kick in that fiduciary duty for others other than the police officer. Keep that in mind, because remember, because you're working for the state does not make you a government employee, because there are separations. But understand how those separations work, because most of our prisons are privatized. They're businesses. They're not state-run facilities. But with that special relationship that's created from that arrest, you are now up to having that relationship to create a fiduciary duty where liability can be attached for your treatment. Now, Shawnee v. Winnebago County, Winnebago, I'm going to guess it's Winnebago County, 1989. While the court held the state generally has no duty to protect private citizens from harm by others, it is made clear that such a duty does arise when the state takes someone into custody and cuts off of their ability to protect themselves. Because We have things like stand your ground. We have the Second Amendment, the right to bear arms. And we also have the right and duty to protect our persons, our places, and our property. Always understand that. So whenever that is taken away, someone else assumes that liability because they then become the parent. You become the dependent. And as a dependent, they're just like they speak about dependency for the child. These are now dependencies for those that are assuming the parent position in your life. They have a responsibility to make sure you are well. And once they've been notified of it, they have a time limit stamped to it. And even the Eighth Amendment with convicted prisoners. Estelle v. Gamble, 1976. It's a landmark case establishing that deliberate indifference to serious medical needs of prisoners constitute cruel and unusual punishment under the Eighth Amendment. Farmer v. Burner clarified that prison officials can be liable when they know of or disregard the excessive risk to inmate health and safety. Now, there is a caveat of things that can be thrown in under the Eighth Amendment due to there are other inmates that are in there that can cause harm. There leaking faucet, there's mold, there's no working AC. And we've actually looked at some prison conditions in Alabama where you got 4 and 5 people in a 2-man cell, and then you're having prisoners that are malnutritioned. These are all not only civil rights violations, but these are all federal crimes. These are things in which you can actually hold the prison liable for. And even in doing these things, if you had a loved one that was injured in jail or in the prison system, the system is liable. And there are ways in which you can hold them responsible. Now, I talk about this because, again, I want to make sure people understand they are not helpless. You are in a land to which there are guidelines for everyone to abide by, even the government, even those that are choosing to protect us. They have a duty and they have a means in which that duty is supposed to be executed. And when they don't, they have a then responsibility to you. And there are ways that you can hit them without hitting other taxpayers. But again, in order to affect change, you must also be ready to affect the things that aren't changing. And that is done by holding them liable for not following the system that they are part of and that was set up with rules and guidelines that they are not abiding by. Because again, they're creating rules and guidelines and they're saying you're not abiding by them, and they have no problem with putting you in a condition that is detrimental to your life. So here we go. Anyway, now the 14th Amendment, pretrial detainees. Pretrial detainees have not been convicted, so the 8th Amendment does not apply yet. Instead, the due process clause of the 14th Amendment protects them. Now, in the world. There we go. Hands doing too much over here. City of River versus Massachusetts General Hospital held that the government must provide medical care to persons injured while being apprehended by police. Now, here's the thing. What happens again is one of those where I've had people say, oh, well, they would not give me my medical records. Now, this is why whenever you're doing a detailed discovery, this needs to be known by your defense attorney, or if you're defending yourself, you must make sure that the prosecution gets this information because it is now the property of the arresting department. And the prosecution is liable for that information. Always understand that. Prosecutors bringing this case, they are now liable and responsible for the information coming from the hospital if the hospital will not give it to you. Because technically it doesn't fall under HIPAA because you're being treated under someone else's insurance. That's where the separation comes in. Now, I've had a couple people that actually went out, asked for it at the hospital. Hospital had no problem because it was technically their records. But understand, if you have issue getting them, make the note of it that you went and asked for them, and that you were told the police have them. So it's now the responsibility of the prosecution to get those records. Now, Kingsley v. Hendrickson, 2015, strengthened protections for pretrial detainees, holding that excessive force claims are judged by an objective, reasonable standard, not by the officer's subjective intent. Now, we've watched these videos where these people are being booked in, or even the young lady that was at the hospital. She was pushed out the door because she was asking for basically information from the officer, since they stood there and waited for her. And then when they pushed her out the door, now one officer was fired and charged, and the other 4 officers were disciplined because they sat there and watched it, and they have a duty to intervene. Now, the reason why they were done the way they were done is so the department can say, hey, we punished them. So now you have to sue the officers in their individual capacity because they broke the rules, and the rules that rule holders, for the most part, have now thrown their ass on the bus and said, hey, you're on your own. Don't involve us in your mess. And this is one of those things that you can do that. Because, again, if you are injured while being arrested, they are liable for those injuries. If you are injured while you're being detained, waiting on court, they are liable for those injuries. If you are injured while you're in prison, the state is liable for your injuries. Again, this is not my opinion. Just gave you a bunch of Supreme Court cases. And if I was doing a case, I then could actually put together something with everything that you would need based on things that are in that state. Because once it's done, once it's set up, you cannot change the Supreme Court rulings. Now, give you kind of a different perspective. If your client, let's say it was you, is suffered neglect in custody, which would be medical, injury, unsafe housing, abuse, your argument will be a constitutional violation and get suppression of evidence if the mistreatment tainted statements or confessions. You have a lawsuit available under 1983 for damages, and use the built-in injury against this for sympathy with the jury. The state couldn't even protect him when they had him locked up. Now they want you to trust their story about him. And that's one of those things that you kind of catch, because you use the opportunities and options that are set for you. You become like water. Make sure you catch them. Take those negatives, make them positive to your advantage, and then you keep moving forward. Now, even if you have prosecutorial pushbacks, prosecutors, again, because I'm not just going to give you defenses, I'm going to tell you tendencies and tactics of the prosecution. Prosecutors will argue that only deliberate indifference, not mere neglect or negligence, triggers liabilities. They'll cite Daniels v. Williams, where the court held negligence alone is not enough for a constitutional violation. Well, in fact, those generally don't hold up if you have someone there that understands how to go around and maneuver their pushbacks. Now, give you kind of an action plan. In custody, you're a ward of the state. The government is legally on the hook for your health, safety, and humane treatment. Understand the standards. Talked about the pretrial detainees. You're waiting on trial, the 80%. You'll go under Fourth Amendment, objective reasonableness. If you're convicted, the 19, 20, blah, blah, blah percent. It's an Eighth Amendment violation. and you will look for deliberate indifference. And in looking for that is understanding what the guidelines for that is. Cases you're going to cite in motions and arguments is going to be estelle, which is medical care duty. Farmer, knowledge of risk. City arena is your arrestees. And then Kinsley, objective test for pretrial detainees. And Deshaun is special relationship in custody. And the use and offense, your rights were violated in custody. This can create a civil claim, a suppressed motion, or a powerful narrative against the state's credibility. Now, understanding, having the ability to stand up for yourself and make sure you are taken care of in a diligent manner is the ability to remain human. Now, I want to put this close into perspective. The state loves to tell the public that once someone is arrested, they've got them under control. But control isn't just about keeping someone behind bars. Control equals responsibility. I'm going to say that one more time. Because the state loves to tell people when they arrest someone, they've got them under control. But control isn't about keeping someone behind bars. Control equals responsibility. When police or jailers lock you up, they're not just holding your body. They're assuming the role of caretaker. They own your food. They own your shelter. They own your access to medicine. They own your physical safety. And you can't leave. You can't make choices. And so, by law, the choices are now theirs. And the consequences fall squarely on them. Now, the Supreme Court has made it crystal clear. They cannot be deliberately indifferent to your medical needs. This includes dental. They cannot not only expose you to harm and just look the other way. That includes other inmates. And they cannot deny you humane treatment and then claim immunity. That's where the special relationship comes in at. Because whenever you're talking about it, it's to show that there is a responsibility and a duty to you that was agreed upon, and that comes from the arrest and their employment. And here's why that matters. In a courtroom, this principle can turn tables. When you're defending yourself, you remind juries and judges, the state had custody of me. They couldn't even keep me safe. They couldn't even meet the constitutional duty. And now they want you to believe a story beyond reasonable doubt. This cuts to their credibility. And it's bigger than just a trial strategy. This is about human dignity. A society is judged by how it treats its most vulnerable, especially those it restrains. Because I remember one of the movies they was talking about, it said society is judged by the conditions of their prisons. And I thought that was amazing because right after that, I looked at a video about an Alabama prison where multiple people were living in their own feces. And the governor attempted to state that he had no idea when in fact there were several families that had been notifying the governor for months. But going through that, when the government takes away liberty, it does not get to abandon responsibility, because control means responsibility. And that's the trade-off baked into the Constitution itself. So remember this, custody is not the end of rights. Custody is the trigger that turns up the heat of government duty. If they fail in that duty, the law gives you the tools, motions, lawsuits, civil actions, to hold them accountable. I'm going to say that one more time. Once you are arrested and you have an interaction, the law gives you tools. Why? Because I said the law is a tool. It gives you motions, lawsuits, civil rights actions, and you can hold them accountable for not doing their duty. And this is where the power shifts. Because once you understand that you are not powerless in custody, that the Constitution follows you inside the walls, you begin to see what this is. You may have your body, but the law still has your back. Always understand that. Supreme, and I'll see you guys in a few minutes.